So my presentation is an update. It differs from last year where I sort of walked through everything, so it is sort of structured as an update. Here's my roadmap. Punchlines. When I'm training young lawyers, I always tell them, get the punchline out, then talk about, what we need to talk about. Everybody wants to know the punchline. So I'm going to try to give you a few punchlines before we get into it. We'll talk about the problem, which is sort of a walk through some history. We'll talk about the U.S. solution. We'll talk about the EU solution. And we talk about the U.S. solution. We'll talk about some state database breach, but in particular the California, their new CCPA, as well as Louisiana is now on release 2, just as last summer, of their database breach statute. So here's my disclaimer. None of this is legal advice, and none of this forms an attorney-client relationship. I have to say all that, so there it is. By the way, as Daryl said, we'll have this presentation up sometime in the next few days, I guess. And here's my second disclaimer, and Daryl alluded to it. So you're going to feel like you're drinking from a fire hydrant. So that's my disclaimer. Here we go. Buckle up. So ready or not, right? Ready or not, the United States is being dragged into this new privacy regime by the European Union. Like it or not, ready or not, we are here. And by the way, California, with their what they passed last summer, they are helping drag the United States into this. And by the way, Washington State now has their basically almost duplicate of the California statute before their legislature. So we certainly expect this bubbling up, across the country. Second, the EU, the European Union, has one system. That's how it's designed, one sort of integrated, operable system. And then the United States, though, the exact opposite, right? Polar opposite. We have all these separate privacy statutes and systems. Who are these guys, right? These guys are the guys who are coming over, the European data protection authorities, and what do they want? They want to know what you're doing with their precious data. And if they don't like what you're doing or you're not respecting their data, right, they're going to ask for these fines. And the fines are very large, 20 million euro or 4% of your gross, right? So think about what that does to your margin if they're taking 4% off the top, right? Cookies. Cookies have become very expensive. Google was just fined 50 million euro for their cookies policy. We'll talk about it some more. It's really more than just cookies, but that's sort of an easy way to discuss it. What is this? The Privacy Shield, right? So the Privacy Shield is alive to fight another day. This is the transatlantic deal between the Europeans and the United States, and it's up for renewal every now and then, and we just passed again in December. So we still have it. You can opt into it. It's self-certifying, and it stops those data protection guys from fining you. But as I say, hello, Federal Trade Commission. Federal Trade Commission is the big dog. They've had a lot of big bats, and they're not bashful about swinging these bats. Many, many statutes give them many, many powers. Follow the data. That's what this is all about. Follow the data in this new privacy regime. Wherever it takes you, wherever the data is coming from, you need to follow the data. It's tough. It's hard to figure it all out, can be frustrating, right? But easy is not an option. I'll talk a little bit about the NIST cybersecurity framework, something that I think is relevant now. You need to think about looking at it. A lot of homework to do in that. And you need to figure out what in that works for you, right? That's not one size fits all. It's a framework to go through what works for you in that framework. At the end of the day, it's really about your tolerance for risk. When you go through that framework or whatever assessment you go through, a lot of it is your tolerance for risk. So here we go. This is the timeline. Massive data breaches, right? Target, Home Depot, Sony, Yahoo, Equifax, right? Facebook, Cambridge Analytica, right? Here's, Mr. Zuckerberg, right? FTC said to be considering large Facebook fines, and in fact, the most recent press just a few weeks ago is that multi-billion-dollar fines are being negotiated right now between Facebook and the FTC. And the Europeans, the Privacy Shield, they are watching. They are watching. So the result's not good for management, right? All these CEOs have been fired or resigned, right? Every one of them in all these breaches. Let's go on to the other part of this story, which is passwords. I've talked about this in all these presentations. It's just a great slide. 1.4 billion clear text credentials were released about a year and a half ago, and these are the passwords. You probably can't read that, but I blew up these 15, right? 1, 2, 3, 4, 5, 6. 9 million people in this 1.4 billion clear text are using 1, 2, 3, 4, 5, 6 as their password, right? And you can look at these, or 111, or they go through the keyboard, 1Q, 2W, 3E, 4R, right? So these are not good passwords. And by the way, and you hear me say this is blocking and tackling at this point. This is not exotic X's and O's. You know, having a good password policy is very important to your security, but to your liability in this arena. So talking about passwords, LinkedIn, right? LinkedIn was hacked back actually in 2012, but nobody knew about it for 3 or 4 years, right? So it was sort of came out in 2016. So you don't have to raise your hands, but how many of you have changed your LinkedIn password? Because it's been out there for a number of years. Have I been pawned or owned, however you want to say this? For those who are gamers, they know what this means. It means you own, you kind of blew away the competition. You own that other character. I'm not a gamer, but that's what I'm told this is. You can go to this website and put in your email address, and it will tell you in how many databases on the dark web or that have been released some sort of way where your email address appears. You can put in your email address, you can put in your buddy's email address, you can put in your colleagues' email addresses. It's all there. Doesn't mean you've necessarily been hacked, doesn't mean that the passwords are out there, but it means your email address has appeared somewhere. And the young man who runs this is a Microsoft regional partner down in Australia. And recently, he came out with this website where you can figure out if your password has made it out there into the dark web. And you might say, well, I'm not going to put my password there, right? Why am I going to go put my password on some website, right? I don't trust that. So here's what you can do. You can he uses a certain hashing algorithm. You can go look at his website. You can take your password, you can run it through that algorithm yourself, and just send him the first 5 or 6 letters, the prefix of the hash code, which if you've seen a hash code, it's like this long, right? And then he will send you back all the hash codes that have those first 5 letters. So you might get 10, you might get 300. And then you can check your string against all of those to see if you're out there. And he gives a number of how many times that password has appeared in all those databases. And if it's appeared, like if it's 1, 2, 3, 4, 5, 6, well, it's going to appear, you know, billions of 100 million times or whatever. But if it appears once, right, because you had your great-grandfather's the 4 names and you put a pound and an at and a $ between the names, right, and you think that's a good password, and you hash it and you look at it, returns it, and 1, that's probably your password that's been out there and has been hacked. So it's something to think about. Why did he do this? Because the National Institute of Standards, the NIST cybersecurity framework said to everyone, well, when people are logging into your systems or setting up their accounts, are you checking that these passwords haven't already been hacked? Are you doing that? Because that would be a good thing to do. So this young man down there, he says, well, here, I'm going to put up all these databases and let people do this to comply with this suggestion from the cybersecurity framework. And by the way, if you don't trust his site, he has all the databases. You can download all the databases. It's a lot of data, and you can run the searches yourself. So it's pretty open. So don't forget about the small breaches, right? And my message today is email phishing is probably the #1 attack vector. Most of you in the room probably know that, but that's really what it is. We'll see that report from several agencies and authorities. The Internet of Things, Darryl had mentioned this, right? We've got this hockey stick, right, of all these devices that are coming on. How are we going to protect all these devices, right? It's almost overwhelming, right? Billions and billions and billions of devices, right? Back in 2015, the Federal Trade Commission put out a report. They were telling Congress, they were shouting at Congress, You need to do something about this. We're melding the virtual and physical world. It's difficult to comprehend how all this is really going to play out. The pervasive introduction of all these devices in these intimate spaces, in our home, in our cars, everywhere. Congress, please, please do something about it. And by the way, don't just fix the Internet of Things. Give us what we all want, which is a national database breach standard. Maybe today people would say more of a GDPR sort of standard, but back then we're at least trying to obtain a national database breach standard. Well, Congress didn't listen to the Federal Trade Commission on the national database, although it actually is something that was introduced last month. But this came about in March, so just a few weeks ago, an act to basically set minimum standards for the Internet of Things. And they're doing this by saying no device can connect to the federal system, to any of the federal computers, unless they meet these standards. And they hope by doing that, right, they will drive a standard for privacy and security in all of these devices. Why is security hard? Some of you have seen this slide before. You know, there's a market out there, right, for zero-day exploits, right? It's out there. And of course, we have our NSA, also known as the Equation Group, who was having a lot of fun around the world, beating up on all of our folks that we don't get along with for the most part in the world, right? Well, what happened is they got hacked, right? So some of the NSA's best, their toolbox, right, their little toy box got hacked. So all those are out there, and now we're dealing with all of those. Our understanding of the threat has changed. Before 2012, we said, hey, we can stop these hacks. Just load up your virus software and make sure your wall is configured properly, and we'll be okay, right? Then we get to after 2012, where Robert Mueller, who was then the FBI director, says there are only two types of companies: those that have been hacked and those that will be. And even that's merging into one: those that have been hacked and will be again. Come 2014, Mr. Comey is now the director of the FBI, and he says there are only two kinds of big companies: those who have been hacked by the Chinese and those who don't know that they've been hacked by the Chinese, right? Think about the LinkedIn thing, right? 4 years, we didn't know. And that's really where we are today. We've gone from I can stop it to I can't even detect it. What do I need to do to detect it? Which is why these frameworks, whether you're ISO 2007 or you want to go to the NIST cybersecurity framework or follow the HIPAA, you have to do something to at least try and fend off this problem. So here's a statement from Mueller back in 12, right? Terrorism remains the FBI's top priority, but in not too distant future, it's the cyber threat that might pose the greatest threat, to our country. All right, so what's the U.S. solution, right? So that was the background. This is the U.S. solution: siloed, sectored, right? So we have the Fair Credit Reporting Act, which at bottom is really a privacy statute, right? So dealing with some consumer information for credit and insurance and employment, right? Then we have HIPAA, right, which works in the medical space, right? But not every medical issue is under HIPAA. So if you swab your saliva and send it off to one of these genome companies, that's not under HIPAA. That's not a covered entity, but certainly you might think that that's medical information. GLB, right? Everybody in the financial community knows about GLB for the banks, right? And then we have 50 state. Every state now has a database breach law. Plus, we now have California's Consumer Act. So that is how we work the system compared to the European Union, which has one system. Here's the waterfall of federal statutes. I'll start in 1970. It might be hard to read, but we start with the Fair Credit Reporting Act, and the color here is that black means good for privacy and red means not good for privacy. It's not a judgment on the statute. It's just trying to grade, is this helping privacy or going against privacy issues. So 1970, we have the Fair Credit Reporting Act, and then we move on to the Privacy Protection Act. What do we have? The Cable Communications Act, the Electronic Communications Privacy Act, right? Again, more sectors, more silos. We're doing it that way instead of approaching it from the top globally. Driver's Privacy Protection Act. I've mentioned before I had to deal with this. So think of all the data that the DMV has about you and your car and that information, regulating that. The blue is the European Union. So think they're across the Atlantic. That's my blue. In 1995, the European Union says, radical, right? Privacy is a fundamental right. And that is their view of it. That is their holistic view of it. And so they start with that. 1996, we get HIPAA, right? In 1999, we get GLB. In 2001, because of the awful events of September 11th, we get the Patriot Act, which is sort of going against privacy. And then California hops on the scene. The green in all these is California. They passed the first database breach statute in 2002. I put it up here so you can see all the component parts of it. Most states sort of copied this, as did Louisiana, and it's been upgraded a couple of times. It's very, for those who are familiar with HIPAA, it's very, very HIPAA-ish. Flow down to business associates, so like the government likes that, right? I have a contract, and I push these contractual clauses down to my suppliers and my contractors. Can-Spam Act, California gets busy again. 2003, the Online Privacy Protection Act. 2005, the Shine the Light Act, and some others. 2006, Louisiana comes on the scene. This is my color here from Mardi Gras, right? So we get our first database breach statute. So we were pretty early in the game for Louisiana. 2008, California passes this bodily implanted ID. So if you have truck drivers or whoever you're trying to track, right, you want to, hey, well, just put this little thing under your skin so I can track where you are, right? California said, no, can't do that. 2009, we get the High-Tech Act, which is a radical upgrade to HIPAA. This is where two things happen. Congress said, big fines, but oh, by the way, encrypt. Encrypt was a safe harbor. And maybe today, 10 years later, everybody thinks, oh, encryption. But back then, a lot of us were thinking, I don't want to go encryption. It hurts the performance of my computers. It's all these other issues, right? Nobody talks about that anymore. I haven't heard anybody talk about encryption being a performance issue anymore. All I hear is, well, we got encryption, and we got another layer of encryption, right? We got multiple layers of encryption. So, but anyway, this was the government saying, you need to encrypt or we're going to fine you. So that was their carrot and stick approach. 2012, European Union again, they say, well, we had that 1990, directive, but we need to do something more. And this is the start of what we now know today as the GDPR. And so they start looking at that in 2012. California does something with drones in 2014. In 2015, they passed the first right to be forgotten statute. And this is only for children, for all the goofy things they put on Facebook and Instagram when they were 12 and 13 and 14, so you get to wipe that out. But if you put something goofy out there, too bad, this statute doesn't help you. So then in 2016, we get the GDPR. And some of you may be saying, wait, 2016? Yes. We had 2 years to get ready for it, right? It was passed in May of 16, effective in May of 2018. How many people were really paying attention? Probably not as many as should. And so here we are. So this is the United States, the European Union dragging the United States into this new privacy regime. 2017, New York passes, the Department of Financial Services passes, basically this is GLB on steroids, as I refer to it. We'll talk about it, have a slide on it. Delaware, and I just picked these guys because this is sort of the trend, shortening the time for giving a database breach notice and mandating 1 year free of credit monitoring, right? So then in 2018, the GDPR is here now, so we've had it for 10 months, right? And then California, as I mentioned, passed their Consumer Privacy Act, which goes into effect January 1st of 2020, although the state AG cannot start enforcing until July. So the private right of action for a database breach starts January 1, but the AG doesn't really get to start doing anything, until July 1st. So again, the European Union is now helped by California, and as I mentioned, Washington, dragging the United States into this new privacy regime. 2018, we in Louisiana, this is our release 2. We've upgraded our database breach statute. This is important. Ohio passes a cybersecurity safe harbor law. And why is this important? Because this is the first time that someone is referring to some real standards or some kind of a framework. They refer to ISO 27001, they refer to the NIST cybersecurity framework. So because all of us have said, well, all the statutes ever said is do what's reasonable, assess yourself. Well, now you have Ohio at least saying, well, here are some standards or some frameworks. If you go run through those drills, you've got a safe harbor for liability. So I think it's very significant. There's Washington, who introduced their CCPA in January, and not law yet, but I think everybody expects it to pass. And so we get just a month or so ago a congressional statute, to deal with national database breach that would preempt all these state laws, including this new California law. And of course, it makes the Federal Trade Commission the big dog, and there's no private right of action. And you might say, all right, well, Congress is finally doing what they're supposed to do, right? Well, here's what I'll tell you. Every Congress for the last 4 Congresses has had some sort of database, national database privacy statute that we all wanted. It's never come through, notwithstanding Home Depot and Sony and Yahoo and Equifax, right? So will Congress really pass something this time? Don't know. We'll see. This is what's in the statute. It preempts state law, no private right of action. The point I highlighted is it has 10 years, if there's a violation, 10 years of free credit monitoring. So I was sort of surprised to see that. Again, this is just proposed. It hasn't gone anywhere. It was just introduced. It's very HIPAA-ish, even uses the term covered entity and those same ideas of, administrative, technical, and physical controls. So those in the HIPAA world or even GLB, you're sort of familiar with that. It exempts banks, airlines, and the livestock meat packing industry are excluded, but the telecoms and nonprofits are expressly included in this statute. By the way, a partial Social Security number is statutorily deemed to be personally identifiable information. And I know there were a lot of folks who thought if they, truncated the Social Security number that would help. Well, maybe it was a good thing to do back then, but if this passes, probably not a good thing to do. There is an exemption for contracts, so you got a terms of service on your website. Is that a contract? Would that somehow still allow the user to have some other rights? Don't know, just throwing it out there. Fair Credit Reporting Act, rolling on, right? This is not just about consumer payment history, right? It's really a privacy statute, and it's about employment, lifestyle, mode of living, character, reputation, and medical information. Very, very, very broad. The definition of what a consumer report is and a consumer reporting agency are very, very broad. And if you don't believe me, think about Spokio. This is the best example I have. Some Stanford students start aggregating all the data of their friends, and it kind of grows. And then some folks say, hey, some businesses say, hey, well, we'll pay you if we can go, mine that and get some information about these candidates. Spokio says, all right, we're making money now, right? So they start doing that, and then someone tells them, I think you got a problem. And so they change their terms of service in 2010 and say, we are not a credit reporting agency. Well, sort of too late. Federal Trade Commission comes in, $800,000 fine, have a 20-year consent decree, and that's how the FTC works. They get you under their thumb with a 20-year consent decree, and Spokio has to do some things. And why am I mentioning this? Because you may be aggregating, you probably are, or your customers or clients are aggregating a lot of data. And what are you doing with that data? Or have you unwittingly become some sort of a consumer reporting agency? So now, this is what Spokio says. Don't do this. Don't do the employment screening. Don't do this because we aren't that. They have to say that. HIPAA. Go on to HIPAA. We have the security rule and the privacy rule, right? Everybody who's in HIPAA knows that. You have to do your risk assessment, right? And the idea here is that you do that for yourself, right? So what an Ochsner clinic would do, or what a 3-doc practice would do, right? And what their results would be likely radically different, the threat vectors and the issues. So it's that personalized, figuring out your own assessment and coming up with your plan for that. Then I mentioned high tech. That was the big upgrade in 2009, 10 years. right? Big fines, but encryption, encryption, encryption. And it also implemented what you might take for granted now is the business associates. Before high tech, you had to flow down these contractual provisions to grab your vendors and contractors. Now, they did away with that. That was like a contrivance. We don't need to do that. They can just directly regulate all those suppliers and vendors to covered entities. They maintain a wall of shame. It's interesting to go look there and see who they're investigating. Right now, there are 433 cases under investigation, and that's all since April 1st of 2017. So there are more under investigation, but they just post the last 24 months of incidents that were reported that are under investigation. And here's an example, MD Anderson, right, a wonderful institution, right, 3 data breaches in 2012 and 13. What are these? An unencrypted laptop, and 2 thumb drives, right? And again, what happens? MD Anderson, they do the right thing. They do their risk assessment back in 2006, and they say, there's real exposure if these things are not encrypted, but they don't do anything for 5 years. And then they have these incidents. And they didn't even manage their inventory to make sure that all the devices were encrypted. And so they write them up, $4.3 million fine, trying to get everybody's attention. And again, this is blocking and tackling, right? This has been out there for 10 years. This is not exotic X's and O's. If you're not encrypting all your devices, then you have, I think, exposure. These are some ones from a couple years ago. The physician owned the server and was configuring, right? So if you're doing your assessment, you should know where all your servers are. You should know where all your equipment is, and certainly they shouldn't be owned or controlled by, the physician, right? They should be owned by or leased by the entity. The University of Mississippi at Ole Miss, I put this one in here just because this is the same thing. An unencrypted laptop gets out there, and so they get fined. Recently, just to show you the other aspects of this, these 3 institutions in Massachusetts were fined $1 million between the 3 of them. They spread it around the 3 because they let an ABC film go in there and run some documentary and didn't get the permission of all the patients. So they got slammed. Sort of more in the popular press at Northwestern, 50 employees were fired for accessing Jussie Smollett's records. And this is an interesting article from about a year ago. The insider threat, and Darryl had mentioned this too, in particular in the medical space, is that the issues are from insiders. 6 out of 10 incidents are insiders. And why? Because there's this dollar, right? There's this incentive for tax fraud, open lines of credit, and other fraud. And then there's just this fun curiosity thing, like the one I just said about Northwestern, So for whatever reason, the medical space sort of has that problem different from some others. This is Accenture's great infographic from back in 2017. 1 in 4, consumers have had their healthcare data stolen in some sort of way, and it shows the various ways the data has been used. So the Office of Civil Rights, this is under HIPAA, right, conclude 2018 with an all-time record year of fining people, right? They are very busy. They're a beehive of activity, happy to fine people. Of course, in this was a $16 million fine against Anthem. Anthem was back in 2015. That was 38 million records. So they finally got around the last, took them 4 years, but they fined them a lot. So that's part of the reason their stats went up. All right, GLB, the Federal Trade Commission, enforces that under the safeguards rule. My best example there is TaxSlayer, only because, well, for 2 reasons. Because they really weren't doing anything right. They weren't doing assessments. They weren't doing anything. It's sort of the list of things not to do. And they had what they call a list validation attack, which is how many of you have used your same credentials on multiple accounts, right? Multiple portals. So the list validation attack is someone gets access to that, and then they take it and they just start throwing it against other portals to see if any of those credentials will go through. And the FTC is saying, you should have anticipated that. And that is part of this whole privacy data regime. You must anticipate the threat vectors. And they said, you should have anticipated that. And they didn't. And so they're, under a 20-year consent decree. But also, at the end, I want to go on back to passwords and all that. In the settlement agreement, they post all these settlement agreements, on their FTC website. they ask you, have you considered multi-factor authentication, right? This is the way the FTC works, right? In all these settlements, they signal, they message, are you doing this? And they don't mean TaxSlayer, they mean all of us. Are you doing this? So you can read through these settlement agreements and get a good feel for what the FTC is very interested in and what they're going to start investigating people on in the future. I will talk about Venmo. That was a peer-to-peer thing. They weren't doing anything right, and then when PayPal bought them, they said, you're not doing anything right, and PayPal cleaned them up. Back to the New York cybersecurity. Again, more stringent. The CISO reports to the board. And in this, unlike a lot of these statutes, they say you shall do annual penetration testing. You shall do biannual vulnerability assessments. That's different than a lot of statutes where they say do what's reasonable, do what's reasonable. They're telling you at least need to do those two things. And I highlight here the limits on data retention, right? So this is this whole concept about data minimization. And there's sort of two perspectives on that. Do I really need all that data when I'm onboarding or doing my intake, right? And the second thing is, how long do I need to hold that data, right? So that's this idea about, you know, having in your plan, how long you're going to hold it, and did you really need to seek that data on the front end? So here's the summary from the New York Department of Financial Services from December. They said, hey, by the way, don't forget you have to certify every year, and that was February 15th. By March 1st, so that was a month ago, right, your risk assessment needed to be complete under their statute, right? You needed to have your policies in place. And by the way, you need to have a, quote, robust cybersecurity program in place as of March 1st. Now, this is interesting. They received over 1,000 breach notices in that span, and the one that stood out was email phishing. They said significant numbers stem from employees providing credentials to attractive emails, right, that trick a user, often disguised an email from a customer that the employee trusts, and so that sort of piques their interest. And so the Department of Financial Services answer was the answer they've been repeating all along: multi-factor authentication, particularly in the financial services space, but maybe starting to, you know, get outside that space is blocking and tackling, right? And here's the note: they observed a decline in reported events once they went to multi-factor authentication. And you may have had that experience as well, but here's the regulators saying, and it works, right? It works. And of course, encryption and training. So here's the FTC in enforcing. We have UPromise, which was a university sort of thing, you know, trying to help consumers save for college, and they had this plug-in for their dashboard that was collecting all sorts of information that they weren't telling people about, and they're under a consent decree, and then they just kind of like blow off the consent decree, and so the FTC comes in again and says, I can't believe you ignored our consent decree. So they come in again, they slam them again, and now they have third-party assessments coming in. So basically there's a policeman who's coming in to check what are they doing with their browser plugin. So the FTC, to make no mistakes about it, is saying you are going to have to pay for a policeman to come in and watch what you're doing to make sure that you're in compliance. That's the way the FTC works. So the Privacy Shield, right? So the Privacy Shield is this is FTC enforcement. Privacy Shield is an opt-in. Well, at least these 4 companies, I think there are a few more under investigation, said, hey, we've self-certified, we're in, we're good. Well, no, they weren't, and so that was a misrepresentation, you know, to their customers or users, and so the FTC, you know, I don't think they fined them, but they're, of course, under a 20-year consent decree. And that's sort of, and I'll show you another thing with the EU as sort of a result of that. Wyndham took on the FTC and lost. They were basically saying, FTC, you don't have the authority to do this, and even if you do, you have to tell me. You just can't say, go do something reasonable. You have to tell me what I'm supposed to do. You have to tell me what I'm supposed to follow. Well, the FTC lost on both counts. The FTC, this is sort of beating their chest saying, this has affirmed our role in this area. Remember, and Congress hadn't really done anything, so the FTC is moving into the space. And it says, all we have to do is make sure that you're taking reasonable steps. Our role is to see, are you failing to take reasonable steps? So again, no specific standard to point to, but they can look at you in hindsight and say, you didn't use reasonable steps. So the FTC, again, is the big dog, lots of bats. not afraid to wield those bats. Louisiana database breach law. So we got our Release 2 upgrade this summer. They've now said that that constitutes an unfair act or practice, and what that means, they sort of bolted it into the Louisiana Unfair Trade Practices Act, so it gives the Attorney General some more authority, and maybe if it's willful, maybe you get some attorney's fees at the end. They added passport and biometric, to the definition of personally identifiable information. In terms of the time for notice, right, it used to be most expedient without unreasonable delay, and a lot of states are doing this now. They put a bookend on it and say, yeah, but not later than, we said 60, some say 30, some say 7. So it just depends on what state you're in. The cause of action has expanded. It's not just results in unauthorized acquisition, but reasonable likelihood. So that is certainly a more loose, liberal standard, so you would think more causes of action. But here, I think, is the most important part. We now have in the statute saying, you shall implement reasonable security procedures and practices to protect. That was never in the statute before. And there was always a question of, well, what am I supposed to be doing? I know I have these obligations if there is a database breach to report, and so you would think you would put the controls in to do it. But now, make no mistake about it, every business, and we're not talking the medical space that has HIPAA, or the financial space, every business now must have reasonable security procedures in place as of August 1st, 2018 in Louisiana to protect. There's also this new duty to erase, which it's sort of oddly worded. It's really not a right to be forgotten, I don't think. It wasn't intended to be that. It just says, when the records are no longer to be retained, you need to make sure you really, really get rid of these records. So maybe that's all it means. Maybe it means a little more. We'll see. We don't have any cases interpreting it yet. Here's an important part. The Louisiana Attorney General, when the original statute was passed in 2006, put out a regulation that basically said, if you don't notify people, you're going to be fined $5,000 a day for every day that you didn't give the notice. So if anyone's, a lot of you have been through database breaches, you're trying to figure out, do I need to give the breach notice or not? And in particular in Louisiana, because we have a more restrictive, not as consumer friendly. And so we were always worried, well, what does that mean? If I don't give the notice for 3 years, that's 1,000 days. I owe you $5 million? Is that what that means, right? That's a pretty big number. So this comes on the scene and basically says, if you go to the Attorney General and you give them your reasons within that now 60-day period as to why you're still investigating or whatever you're doing, they shall, that's why I put this in green, they shall allow a reasonable extension. So it may not help you with the ultimate issue of you decide not to give the notice and you should have, but at least it gives you some runway to sort of figure this out, as you go through it. Other states, the trends have been address security procedures, pen testing, more ID theft prevention mitigation services, those sorts, more people notifying the AG and expanding the definition of what is personally identifiable information. I throw this slide up here because I think it's interesting, it's historical, and it may help you with the concepts. In 1973, the United States Department of Education, Health, Education, Welfare, studied all the data processing systems, which we used to call them back then, and they came up with these 5 principles. And these have really become the bedrock for a lot of these privacy statutes, including the GDPR. No secret database. You should know where your data is. What database is it in? You should have the right to audit it. You should have some right to say how it's going to be used. You should have the right to correct it if it's not, accurate. And there should be some accountability that it doesn't leak out and that they protect it. Now, again, this isn't the law, but this is what this study said. We need these 5 principles. It was very radical back in 1970. Add to that, we now have, the right to be forgotten. This is the GDPR and some other states who are looking at this. So that's really not in here. Data portability, right? That's a new one. And this data minimization concept. But if you take these 5 and add those 3, that's basically the GDPR. That's basically most of the CCPA. There's a few differences. So, but if you just want to think of it from a high perspective, these are the principles. So what's the EU solution, right? Which they would say is an elegant solution, one solution, right? Everything working together. So privacy is a fundamental right. It's akin to the power, that we have in our Bill of Rights, so it affects every statute, right? It flows down everywhere. We don't care what sector it's in. We're not treating them differently, although they do treat medical information a little more. But basically, it should be pervasive, right? It should be everywhere. And it's the de facto worldwide standard for data privacy. It is. So the Europeans took the lead on it, and it regulates how any company in the world can collect and process the personally identifiable information on Europeans. Last November, it was kind of a cool little article if you want to go spin it up. 60 Minutes, and it was titled "The Law That Lets Europeans Take Back Their Data from Big Tech Companies," right? So the whole idea is follow the data. Why? Because are you offering goods or services to data subjects in the EU? So a bunch of Europeans come here for Mardi Gras or for Jazz Fest or French Quarter Fest, whatever, and they go to our restaurants and hotels, and somehow you get some information. And you throw them into your database, your marketing database, and you're not treating them any differently than you're treating all of your contacts in the US. So when they go back and they've got that pixel or that beacon or whatever it is, and you're bringing that data back across the pond, that's why I say follow the data, you are now into the GDPR. So if you're not looking at your Europeans who are in your database different than your United States, at least for that purpose, that's how this works. So these guys are coming for your money. You need to think about the Privacy Shield. 4,200 companies, this is as of December, are in the Privacy Shield. As I said, the EU approved us again. They gave us their adequacy decision. But now the Department of Commerce, if you're the first time going in to get your Privacy Shield, they'll let you self-certify, but they won't let you tell anybody until they look at your application. The Department of Commerce is now spot checking companies when they go in for their annual renewal under the Privacy Shield, and the FTC is conducting, just sort of random sweeps. And a lot of this is because they want everyone to comply, but a lot of this is because the Europeans are looking over our shoulders to make sure we're doing what we're supposed to do if we want to keep the Privacy Shield. The Europeans don't like the fact that the Department of Commerce wouldn't tell them what was going on with Equifax and Facebook, but they are very focused on it. And we just had the DocuSign chairman, Keith Kroc, nominated to be the ombudsperson under the Privacy Shield. So that's the EU solution, comprehensive, transparent, and all these principles 1 through 6 there. And I talked about the cookies. I don't have time to go into this in detail. We'll do it at the panel this afternoon. But basically, they said, no one can figure out, we have to run through so many screens when we're setting up our accounts with Google. You're not transparent, and we can't figure out what you're doing with our information. And it's massive processing. And so we don't know, you violated the transparency and information principle, and you didn't give valid consent. And this is interesting. If you ever tried to configure one of your accounts with someone, and if you really ever care to do that, you go in, there's a whole bunch of pre-checked boxes. They said, that's not consent. That's not unambiguous consent. You need to give the users all those boxes unchecked. And only if a user checks says, yes, you can use my data for that marketing purpose. Is that unambiguous consent? So they basically told Google, you never got anybody's consent. All those consents are gone. So that's what that is. The Bavarian DPA did a random sweep of 40 companies back in February on the Safer Internet Day and found it sobering that none were in compliance, and they are now trying to figure out how many of those companies they are going to find. None of us know who the companies are. We don't know if it's European companies, US companies, but that's where we are. I'm going to do this really quick. This is the GDPR versus the California statute, right? 10 months ago, talked about the CCPA coming on board next year. The big difference is that, the European Union applies for what I said. If you're tracking, unless you have a footprint over there, then you're in the GDPR. But if you don't have a footprint, you're here. The CCPA is really, this is the standard. Do you have gross revenues of 25 million? If you do, well, then you're in, so small businesses might be okay. Or you trade or buy in, personal information, or 50% of your revenue comes from the sale of personal information of California residents. It's expansive, but basically, if you're not collecting California data while that person is in California, you're going to be okay. There's carve-outs for HIPAA and GLB. There's a lot of pushback saying there's no private right of action, saying so it's the Electronic Frontier Foundation said it's sort of gutless, it's just the Attorney General. The Attorney General said, hey, it's sort of gutless, and so now California legislators introduced just last month something saying, hey, we're going to have a private right of action. So that maybe they're going to open it up very broad. This is one interesting part about, while the CCPA doesn't go into a lot of details, they were very, very clear about this. You must put on your home page a click that says, do not sell my personal information. You must have that on your home page, and when you click it, it's supposed to bring you to a very clear site where you can, make that come true. The data subject, it's about the same. The data subject's not just a person. If you start collecting information on a profile and you haven't yet connected it to an individual, a flesh and blood individual, that's a data subject, and the CCPA sort of has the same thing. It regulates processors, whereas CCPA is more like HIPAA before high tech, where they're pushing down contractual clauses to the service providers. There is a Bill of Rights. There's some sort of right to be forgotten, but it only applies to the data they collected, not the data that they got from third parties. So that's sort of a quirky thing, and certainly not like the GDPR. The NIST, all right, this thing's been around for 5 years. Their principles are identify, protect, detect, respond, recover. There's this core that is, very comprehensive to go through. You create a profile of where you are and a profile where you want to be, and basically that's your plan. That's what, that's how the thing works. They have all these, they break it out in a lot of detail, categories, subcategories, all these to take your whole team, through this. This is not just for the IT guys, right? Not just for the CIO. This is all of management. It's directed to the whole organization. And then I said Ohio, passed their safe harbor. So again, I think this is significant because they reference the cybersecurity framework and a few other standards, as well as the ISO, 27000. And they're saying there are no silver bullets here. You need to use the framework to assess and improve, these managements. And again, the full benefits come, if you make sure the whole organization does it and not just the CIO. So all you CIOs out there, I know you're happy that I said that. Other privacy topics, privacy policy, terms of service, right? The FTC enforces that. California has their Online Privacy Protection Act, which has been around, I don't know, like 10 years. And there's a very helpful link on the California AG website that takes you through a tutorial about how to prepare a privacy policy. And I will tell you the worst way to prepare a privacy policy that you're going to post is to go take somebody else's and copy it and say, oh, yeah, well, that privacy policy is a privacy policy, right? Well, the FTC will be knocking on your door because it probably doesn't reflect what you do. So FTC, the takeaways, is not waiting on Congress. The GDPR is here. The CCPA is around the corner. Think about self-certifying for the Privacy Shield. Maybe Congress will do something this time. Who knows? And then my last note here, if you've learned to live with GLB and HIPAA, you have paid your dues and you're well ahead of the game. And if you haven't done that, well, no time like the present to follow the data and get there. So there it is. I promised it would be a lot. It is. So you can unbuckle now. Success is do what's right, the right way, at the right time. There's a lot to go through. It's frustrating. You need to do your homework. Simple's not an option. And at the end of the day, it's really about your tolerance for risk. So, thank you.